Hey guys, Seth Fuller, your Texas trial champion and your favorite attorney here. This is a video about the recent $46 million judgment against a Brazilian Jiu-Jitsu studio and professor. You heard that right, $46 million. If you're watching this video, this is the long form explanation of why that's not necessarily a bad thing. And more importantly, what it means to practitioners and to gym owners. This is a conversation with my good friend Mike Parker of mrparkerlaw.com. He's a purple belt in Brazilian Jiu-Jitsu that I went to law school with, that I've been friends with ever since. That's about, 15 years ago. And he owns one of the bigger personal injury law firms in Los Angeles, highly successful, hundreds of millions of dollars in litigation. And he sat down with me and told me what I didn't know with my little bit of personal injury experience, and we talked about what it means for practitioners, what it means for gym owners, and what it means for everybody. This crazy $46 million judgment. It is about an hour long. If you want a shorter version, go check it out. It will say the same thing, but short version, and that will kind of be an edited, nitty-gritty, way less boring, but not too less boring because it's still 30 minutes. But I just think this topic deserves coverage. I've seen a lot of coverage on Reddit and everywhere, and none of it was, I think, really as explanatory as my great conversation with my good friend Mike was. So thanks for watching, and I hope you enjoy. Tell us who you are.
Okay, so I'm Michael Parker. I'm one of your law school classmates, maybe slightly better grades. I'm a PI attorney in LA. I've done somewhere between 6,000 and 7,000 PI cases. And we have a large office here. We've done a few $100 million in settlements.
What's the name of it?
It's MR Parker Law.
All right, mrparkerlaw.com is where they can go find you.
Yep. Or on Yelp, we got like 500 five-star Yelp reviews. So
yeah,
So
I want to talk with you because obviously I kind of sent you the link. I didn't know if you heard about it, but a guy out there got sued for a lot of money for I think 46 million, 42 million. What was the number?
Yeah, it was somewhere in the $46 million range.
Yeah, 46 million, something like that. This is a Brazilian Jiu-Jitsu school owner. He gets he falls on a kid, he's training with another student who's a competition white belt, is what I would call him, and ends up rolling with them, and ends up paralyzing the kid. And so I want to talk with you because you're on the PI side. You're out there in California, the Brazilian Jiu-Jitsu community, and by the way, you are a blue belt, purple belt. Did you get your purple?
Oh man, purple belt. Come on.
A purple belt in Brazilian Jiu-Jitsu.
Four stripes.
You don't lose them?
I'm like this close to a brown belt.
I thought you started losing them after you don't train for anyways.
I know, for every year you lose a stripe, right? So now I'm back to blue belt.
That's right. So you're familiar with Brazilian Jiu-Jitsu, and
sure.
I'm familiar with Brazilian Jiu-Jitsu. So I want to talk with someone who's familiar with Brazilian Jiu-Jitsu and familiar with personal injury lawsuits like this, big money personal injury lawsuits. So I want to ask you a few questions. First of all, you saw the video.
I did, yeah.
And then were you able to watch that Rener Gracie video?
I did. I watched that as well.
Okay. So it was kind of funny. The first reports out of everything was like this instructor, this black belt instructor, Sinistro, I believe is his nickname. We all have nicknames in Brazilian Jiu-Jitsu, top level instruction. So he's rolling with the white belt, and I'm pretty sure he's not the owner of the gym, but he's the main head instructor, correct? And he's rolling with the white belt, and we hear that he collapsed on top of him, was going too aggressive, and that the kid got paralyzed as a result, quadriplegic. And so I think the immediate thing was outrage, right? Like, you can't do that. What are you doing? Especially black belt on white belt. And then the video comes out after the verdict. And I don't know about you, but when I watched that video, I think it's the whole Brazilian Jiu-Jitsu community had the same reaction, which was like, oh, that's not what you described at all. You know what I'm saying? Like, that was just a guy going for a back take, and one guy turned his head wrong and was paralyzed. It was terrible. It's terrible. It was terrible. Like the guy got, quadriplegic, and it wasn't his fault. I'm not blaming the person who was rolling. Either one, it was an accident. It was a tragic accident. I think even Hinner said that. But basically, then when everybody saw the video, it's literally the pitchforks came out on the other side. They're like, this is something that could happen anywhere. How is this a $46 million lawsuit? And how is he even at fault? Right. And so then it came out that one of the founding members or children of one of the founding members, just basically this royal lineage in Brazilian Jiu-Jitsu, Rener Gracie. I'm saying the right one, right? Correct. They all have very similar names. So it's Rener Gracie. He's kind of a YouTube star. And again, grandson of the founder. And it turns out he was an expert, and his testimony from deposition came out, and a lot of people got their pitchforks out on him saying what you're saying isn't true. And so basically everyone, and then he releases a video that's very reasonable, explains things very well, very similar to what he testified to at trial. And kind of then the pitchforks are kind of put away a little bit, I think. But I want to talk about all this, but I want to give everyone who might watch this like a baseline on what we're talking about. So basically, can you break down, this is a standard personal injury lawsuit, similar to what you might see in a slip and fall in a business, correct? Which is someone got injured. This is not criminal. So the intent is totally different. You don't even have to have intention, just like most car accidents. Most car accidents, there's no intent to get in the car accidents. Do you agree with me?
Yeah, I mean, I think what people don't realize is that this whole situation was probably a mismanagement by the insurance company, right? And I haven't seen any articles that talk about this, right? But you would have never heard about this case if some adjuster somewhere didn't screw up really badly, right? So, I saw a video, it was some guy from Canada, and he goes, well, is this, plaintiff, I think his name's Jack Greener, right? Is he going to get this $46 million? And he goes, no, he's never going to collect it, right? He's never going to get it. They might have $1 million of insurance. Then they'll try to do a payment plan with the jiu-jitsu school. And then, the jiu-jitsu school will probably file bankruptcy. But that's not really what's probably happening here. So, I'm going to kind of back up and talk a little bit about insurance coverage, what an open policy is, and what my intuition is as to what occurred, right? Yes. So, what happens in California is there's no such thing as third-party bad faith, right? And for people who don't understand insurance coverage, for people who don't understand what bad faith is, basically in California, if an insurance carrier who is representing a defendant does not pay fairly, you cannot sue them for acting in bad faith. Right? They got rid of that in California. It just doesn't exist. So in California, there's only what's called first party bad faith. And what that is if your insurance company doesn't protect you and acts in bad faith in their representation of you on the claim, then you can go after them and sue them for first party bad faith, right? So that's a claim that the defendant would have against their own insurance company. Now, what probably happened is that the original attorney on this case, so the trial attorneys were Panish, Shea, Boyle, and Ravapudi. I know the firm. They're very well known in California. They're an excellent law firm. So they're most likely not the original firm. There was a referring firm that probably brought them the case. So what happened is the referring firm probably sent a policy limit demand after the accident to the insurance company or incident. PI attorneys don't like to say accidents, we like to say incidents. And the adjuster who evaluated that case probably did not pay the policy limit. Now, if an insurance carrier is presented an opportunity to settle within policy limits, and it's reasonable that they should settle within policy limits, and they don't, and then the plaintiff goes after the defendant for an excess verdict or personal contribution, then the defendant could have a bad faith claim against the insurance company. And then if you go to trial as a plaintiff and you win money in excess of the policy, that defendant can assign you their bad faith rights in exchange for you not collecting against them. So like, let me kind of back up and, tie that all together.
Let me stop and clarify real quick about that. So basically, to summarize, what you're saying is that, again, the reason we have insurance, any of us have business insurance, is for an accident like this, any accident where someone gets injured. Hey, that person's just not stuck out a quadriplegic with no help doing GoFundMe. Yeah. So again, this isn't necessarily, it's terrible for the business owner. Well, then you hear, but $46 million, $42 million, whatever it is, millions of dollars, how is that possible? But essentially what it is if I have $1 million worth of insurance, you give a demand for $1 million, basically.
Correct.
And then that insurance company can say, okay, that's fine. This kid is way more than $1 million in damages. We're going to give you the $1 million. And then you're done and you go away. The kid gets, 2/3 of $1 million usually, because the lawyer takes a third. But basically everybody's happy. We settle with make sure that the medical bills are reduced. The doctors get paid what they get paid. The poor young man who's going to be quadriplegic, or at least some issues for most of his life, is going to get some money to help for the pain and suffering and to help with that. But basically, usually it's just $1 million, which again, quadriplegic, he's probably out that many times in medical bills so far, not to mention his future medical.
Exactly. So what the adjuster probably did here is look at it and say, hey, look, this guy got hurt doing jujitsu. He assumed the risk. There was probably a liability waiver. And the adjuster probably was just cocky and said, you know what, this guy has a 0 chance of recovering money, so I'm going to deny the claim. And then what happened was the firm that had the case, and this is just my guess. So, I've done, like I said, 6,000 or 7,000 claims, and I've done this before where we make a policy limit demand, they don't pay the demand, and then we get above the policy limits from the insurance company because they acted in bad faith. I've gone to trial on cases, I've gotten above policy, and the insurance company paid. But what probably happened here is you get a cocky adjuster. They say, this is stupid. This is, a physical activity the guy signed up for. This guy signed a waiver. He assumed the risk, and we're not going to pay a dime because we think that either a jury is going to give us or give the plaintiff nothing, or we're going to win on what's called summary judgment. And summary judgment is a motion you can file in court which says, based on the facts, if you accepted them all as true, there's no case essentially. And, there was probably a waiver, and I believe I heard there was a waiver here. Now,
there was a waiver. Now, here's the thing. Let's talk about the waiver in a second, but I wanted to get back so people understand what you said earlier, which is, so now they say, instead of paying the $1 million, which they could do, that's why I buy insurance. And I want, again, even if it's not my fault, I still want this kid to get money for his medical bills, even if it was an accident. So me as a business owner, as an insurance policy holder, I want them to pay. I just want them to give the kid the $1 million and leave me alone. I don't want to pay it, but I don't want to pay it.
The insurance company has a duty to protect their insured. That's the duty of good faith, right?
So the reason they have this rule the reason they have this rule that you're talking about is because then the insurance company should pay the $1 million. If they don't, what then happens there in California, it's different in every state. But essentially, the law office who won the $46 million settlement, they know this gym owner don't have anywhere close to that. So what they do instead is they have him sign basically a contract or an agreement saying, we're not going to come after you. We're going to come after the insurance company. And then they sue the insurance company, who may have to pay the $46 million if they're found to have acted in bad faith by not settling the $1 million. And what usually happens, and you can correct me if I'm wrong, is everybody mediates and then it's settled for an undisclosed amount, maybe 10, maybe $20 million. Everyone gets a big chunk in the pocket, and the only person out is the insurance company, right?
I mean, it might not even be at that big of a discount, because we also have something called a 998 offer, which is a statutory offer to settle. So in California, you can do an official offer, right, by Code of Civil Procedure 998. And if you beat your demand at trial, you also get interest and all your costs from the date that you made that offer. So there could be another $20 million of interest on top of that 46 million from the 998. And they probably certainly did a 998. But I kind of want to back up and talk more about, why this adjuster probably made the decision they made. So, these insurance companies, and the reason they have this assignable bad faith is you don't want insurance companies to gamble with your money, right? To the insurance company, let's say there's a 5% chance, they lose this case and the plaintiff is awarded a lot of money. They only have $1 million on the line. And you don't want them to say, we don't care about our insured. If this person is 50 million, just let our insured file bankruptcy. You don't want them to make decisions that are going to hurt their insured and put the risk on their insured instead of on the carrier. And this is kind of like a punishment for that. And, there's a really well-known case. There's a famous lawyer in California. His name's Nick Raleigh. Excellent trial attorney. Might be the greatest living trial attorney right now that does personal injury. And he had a case with an insurance carrier, one of the major carriers. I think it might have been a $250,000 policy. Little girl suffered some, traumatic brain injury. They did not pay the policy limits. The firm that was representing her brought in Nick, and they ended up mediating the case on an open policy, meaning the insurance carrier was essentially on the hook for above limits, and it settled for 45 million, just about what this case ended up getting at verdict. So, these type of damages are not out of line with what these cases typically settle for, what these cases typically verdict for. And this adjuster should have realized, even if there's a 1% or 5% risk of them getting a verdict, because it's a quadriplegic case, they should pay the limits, even if it's a low probability, because they're basically shifting the risk off of the carrier and they shifted it onto their insured, and they shouldn't be doing that.
Yes. And so just to clarify, and I want to wrap this up, I don't want to take too much of your time. I know you're busy, but just to clarify and to summarize for people, essentially this gym owner and this black belt jiu-jitsu instructor are probably not out any money, probably not almost any money, maybe some legal fees for themselves or something. But again, most of that, probably not.
The gym owner might even potentially get money, because the gym owner might have his own bad faith case against his own carrier, because the entire bad faith case isn't assignable. It's only the breach of contract portion that is assignable to the plaintiff. There's also a pain and suffering, component for the emotional distress that the defendant would have against his own carrier. So it's even possible he could pursue his carrier as well. And just one thing I want to talk about is the waiver, because I did see people talking about it online. And I know we kind of went down a legal rabbit hole on this, but I think it's important for people to understand. They see these big numbers, 46 million, and they think, who's going to pay it? How are they going to pay it? Is it going to ruin the gym owner's life? And I think it's important to realize the insurance company screwed up, and they're the ones who are going to pay it. But going back to the waiver. So in California, you can waive negligence, right? And I think this is where the adjuster probably messed up. Right? But you cannot waive what's called gross negligence. So negligence is just the departure from the ordinary standard of care. You're driving your car, you look down to change the radio, you look up and you rear end someone. That's ordinary negligence, right? But gross negligence in California cannot be waived. And that is the extreme departure from the ordinary standard of care. So for example, if I'm a waiter at a restaurant and I'm running full speed, carrying a knife, and I accidentally stab someone, that's a gross, departure from the ordinary standard of care. And in this instance, my personal opinion is I don't think it was gross negligence. I think this is just, an accident that happened that was ordinary negligence. But you have to understand that normal jurors are not jiu-jitsu practitioners. I've done jiu-jitsu for, 13, 14 years. I know that I've, had my arm overextended in an arm bar. I've been choked nearly unconscious by someone who doesn't hear me, or feel me tap, right? It's just part of, the normal course and scope of doing this activity. But the ordinary person on a juror is going to hear jiu-jitsu master black belt, high-level competitor, did a dangerous move and didn't do it right. And they're not going to understand that when you're doing jiu-jitsu, there's a lot going on and mistakes are made, and that's how you learn. You learn by doing things wrong. So there's a lot of risk there. So I could see how a jury could find that there's gross negligence, or a judge on a summary judgment motion could find that there's gross negligence. But in my personal opinion, I would say it was ordinary negligence. But still, the adjuster has to understand that there's that risk there, that, in a high level activity where there's a catastrophic injury, that the waiver might get thrown out. And to be honest, the more serious the injury, the more likely people are going to let it slide that there's a waiver, because a jury or a judge is going to feel sympathetic that they're not going to want to deprive this really injured person of a lot of money simply because they signed a waiver.
I think that's a really good point, and that goes to kind of what we're talking about, which is everyone's grossed out about this. But in the end, what I'd like to summarize for people about this justice system is this may come down to the only person who is out is the insurance company that you pay to make sure that you aren't out money. So the only people who are out is this multi-billion probably dollar company that, or at least multi-hundreds of $1,000,000 company that should know better, and we pay every month, everybody pays to mitigate this risk, and they're going to be the only ones out, and the only ones benefiting besides the attorneys, which we're okay with. The only ones really benefiting is going to be the young man who was paralyzed through doing a hobby that he enjoyed.
Well, he's lucky that there was a shitty adjuster on this case, to be honest, right? Yeah. I mean, had the adjuster done their job properly on this case, and like I said, I'm making a lot of assumptions. I'm basing this on my experience as a PI lawyer and what I, think happened in this case. I mean, I could be wrong about how it played out, but my guess is this is probably what happened based on having done the same thing myself in many cases. But he's lucky that the insurance company did not pay the limits when they made the initial demand. And here's something I'll tell you and why I think that's the case. The firm Panish, Shea, Boyle, and Ravipudi, the one who represented him at trial, spent $100,000 from what I read just on expert testimony from, I think it was Henry Gracie, right? And they would not shell out that kind of money unless they felt confident that they'd be able to collect at the end of the day. And the trial attorney who was trying that case, who I know very well and who is very well known in the PI community, would not personally try that case. He's one of the name partners at that firm unless he felt like the policy was open and unless he felt like that would be collectible at the end. And no jiu-jitsu school has a $40 million insurance policy. No one, they probably don't even have a $5 million insurance policy. It was probably $1 million.
I think Henry even reported that this was $1 million policy, and that they, again, in order to collect, they have to turn it down, correct?
Correct. Yeah. If the insurance company said we're paying the full $1 million and they offered it and they offered to settle within limits and they did it within the time of the time limit demand, then you could still go after the owner if you want for personal contribution, but good luck collecting it from them because the insurance company is not responsible anymore. They did their duty. They would have acted in good faith, and their own insured would have no bad faith claim against them that they could assign to the plaintiff, which means you'd have to figure out how to get 35 or 45 million out of a guy who does jiu-jitsu all day and probably makes under 100,000 a year. Yeah.
And again, it just doesn't happen. To summarize for everybody, it just generally doesn't happen. Nobody's going to spend any amount of time and doing a lawsuit on someone who's not collectible. We call it judgment proof, and there's no lawyers who are going to touch that.
Yeah. I mean, look, I go after people for personal contribution sometimes. I had a case where someone was rear-ended. They had a significant brain bleed. We settled for, or their insurance offered the $250,000 policy. The defendant was very, very wealthy. And we ended up getting another $400,000 in personal contribution. But that was a situation where the person was underinsured. They were a millionaire. They only had $250,000 in insurance, and they had the money that we could go after, and they were collectible. But in most situations, when someone doesn't have enough insurance, that's because they don't have assets to go after, and they're properly insured for their level of worth.
Okay, so I want to now go to, so now we're to exactly what you said. The one thing I want to cover, this is your assignment, my friend. You got to do this for me as soon as you can. Call your connections at Boyle and Eshkaskuti or whatever you said. All your connections at them.
By the way, you get connections real fast. It's a funny story. And I think I told it to you before I jumped on the podcast. So the firm that actually got this verdict, I've co-counseled cases with them in the past, but they've also sued me. My dog in 2016 ended up biting a guy who was fixing our sprinklers, and Panache and Boyle was the firm that actually sued me as well. So I've been with them on both ends. I've co-counseled cases with them, and they've also actually been sued by them.
Well, you got to find out what happened to the waiver, because I want to talk about that real
Sure.
quick. Everybody signs a waiver. There's also this thing called implied waivers, which
Sure.
is you do a dangerous subject, which, believe it or not, I mean, it's not. I did my law school, what is called technical writing project on implied waiver. And so that was in Texas and everything, but I did it because I was interested in this. But you got to find out what happened to the waiver. I don't see it online. Hinner talked about that it was thrown out, and then he said, consult a lawyer. I am that lawyer. I've done a technical writing paper, but I'm really interested to see, because if someone comes to me, I teach at 2 gyms, so they might come to me and go, hey, how do we prevent this? And honestly, that's what everybody's worried about in the community right now. And honestly, the answer is that I don't know, because I don't know why that waiver was thrown out. And like you said, the important part was the jury found, whether even if there had been a waiver, but those are pretty extensive. The jury found that there was gross negligence, correct?
Well, I don't know in Texas, right, where you are, what the rules are with waivers. But what I can tell you in California is there's no way to absolutely protect yourself if you run activities that are physical, right? If you have a rock climbing gym, if you have a, jiu-jitsu school, if you have a fencing school, right? You can have waivers for ordinary negligence, but you can absolutely not waive gross negligence in California. And the truth of the matter is that the more serious the injury, the more likely that the waiver will get thrown out, and it'll be classified as gross negligence, right? And kind of the reason is like I said, judges and juries tend to have more sympathy for someone who's seriously injured, but also the kind of activities that seriously injure people just seem more extreme, right? Like running through, like I said, a kitchen carrying a knife, or doing, a high risk jiu-jitsu move, or you're doing some, very complex technique when you're bouldering or rock climbing. Right. And those are the ones that typically end up in more serious injuries. You don't really, get seriously injured for running with a glass of water, right? Or looking down at your phone while you're walking and bumping into someone, right? So the types of activities that do cause serious injuries tend to fall in the gross negligence category. And because of that, there's no way to absolutely protect yourself, at least in California.
Yeah, I don't think there is any place. I'm quite sure it's not in Texas, which, again, find this out, because we won't know. But I'm interested because from what I understand, the judge would only throw it out before the jury would generally be able to at least hear about the waiver. It got thrown out, is what I understand. So
there was probably a motion for summary judgment, and I'd have to go look at the docket to find out. But my guess is there was probably a motion for summary judgment. The school, or the carrier for the school, and the defense firm they hired probably said, we have no liability because we have an absolute defense, which was it was a waiver of negligence. And then the judge probably found that, hey, there was gross negligence, and based on the facts that were presented, and I'm not going to grant your motion for summary judgment. It's going to be denied. And then it goes to a jury who is going to hear basically the facts of the case, what happened, what the damages are, and then they're going to adjudicate it. But if it did go to a judge on a motion for summary judgment, the judge would have had to thrown it out, or else it wouldn't have gotten to a jury.
Oh, I gotcha. Okay, I see what you're saying.
And I'll read you, just so you know, the Casey instructions. So in California, there are jury instructions that you can look at, which kind of tell you what these things are. So I pulled it up while we were talking. So this is Casey number 425, and I'll read it just verbatim. It says, gross negligence is the lack of any care or an extreme departure from what a reasonable, careful person would do in the same situation to prevent harm to oneself or others. A person can be grossly negligent by acting or failing to act. So it's really open to interpretation, right? Like, what does it mean to have an extreme departure? Does that mean just doing a regular jiu-jitsu move and doing it incorrectly? Or does that mean doing a high-risk move and doing it incorrectly? I mean, there's no case law on this. There's not a bunch of test cases on jiu-jitsu schools. So it's really going to come down to how egregious are the injuries, right? Like, are they absolutely devastating, or are they, a bent toenail? I guarantee you, if the guy broke his toe in this roll instead of his neck, the judge probably would have thrown out this lawsuit. That's my guess.
Okay, so let's talk about that, because now this is good segue. All right, so me and you both watched the video. We're both regular practitioners of Brazilian Jiu-Jitsu. We watched that video. Again, I think looking at Reddit BJJ, r/BJJ, there's no doubt everyone thought the same thing, which was, while looking at this video, this is something that could have happened at any gym between any two sparring partners. This was not an unusual occurrence, what we saw. You would agree with that?
Oh, 100%. Like I said earlier, I've been injured so many times training, and sometimes it's been by white belts who are just over aggressive, but I've also been injured by black belts too, when they just mess something up. Jiu-jitsu is like chess. It's a constant learning process, right? You're always going to get better. Even if you've been doing it for 30 years, there's always something to learn. And the only way you learn in jiu-jitsu is by practicing in live sparring. And when you practice in live sparring, you're gonna mess things up, and sometimes people get hurt. But what I'll tell you is, everyone understands who practices jiu-jitsu that getting injured is part of the learning process, both for you, but also for the person who's learning on you. And I think you would agree with that.
Yes, and so that's gonna go to my next thing, which is, you watch Rener Gracie's breakdown of it. He was the expert, and a lot of people were hating on them. Then he does this breakdown, and I would say that breakdown was spot on. The things he was talking about, trapping the arm, rolling that is something that, if I were to break down what went wrong, is spot on. There's no doubt what he's talking about was an issue, as far as there's two ways that are generally taught to do this move. He didn't use either of these ways. He used a modified way, and that particular modification resulted in the injury. Would you agree with me on that?
Yeah, I would agree with you on that. But, you have to understand, like I said, and not you specifically, but the people viewing this video, that, that is just simple negligence, in my opinion. Like I said, if I was on the jury, if I was the judge ruling on this motion for summary judgment, I would say that could happen on any move. You put your arm in the wrong place, or you modify. I've modified moves to fit the way that I roll before. There's certain things I do as a jiu-jitsu practitioner that are different than the way it's taught, because it works better for my body type. It works better for my size or my flexibility. So it's not unusual also for people to modify jiu-jitsu moves to fit their style of rolling. And
you're live rolling. It's a back and forth.
Oh, you're going to mess things up left and right. I mean, I've rolled with you, and I've tapped you many times, in the past.
So many times. So many.
Yeah. But no, I mean, you and I have rolled together, and I'm sure when you and I have rolled, we both did things incorrectly, right? Even the limited times you and I have rolled. And, we're lucky it didn't result in injury, but it very well could have. And I guarantee you, if you had injured me or I had injured you, we would have both been like, yeah, that kind of sucks, but it's part of what happens.
But I also want to tie that back to, when you say that this is what everybody grabs onto, I think everybody who does Brazilian Jiu-Jitsu and who's in the community agrees that this was simple negligence.
Oh, I agree. But you have to understand, as an insurance company, and this kind of goes back to what I was saying, the adjuster put the risk on their insured, basically, that the court would agree, or a jury would agree, that this was ordinary negligence. And you have to understand, most people who evaluate this aren't jiu-jitsu practitioners. They're people who are going to hear master jiu-jitsu guy, and he messes up and injures someone.
And more importantly, and I think this is what a lot of people want to hear, and I think this is kind of like the silver lining that I'm trying to get, which is, if it was simple negligence, probably it gets thrown out as summary judgment, and this kid gets no money.
Yeah.
And again, some would say, well, that's the law, that's how it works, and that's how the insurance company deal with it, and my insurance company shouldn't have to face it. If under the letter of the law, it is simple negligence, blah, blah, blah. But in the end, if it's simple negligence, the short answer is this kid probably gets zero, nothing.
Yeah. I mean, here's what I'll tell you. Honestly, this case is good for jiu-jitsu practitioners. And I know people don't want to hear it. It's good because when people get in catastrophic, serious injuries now in jiu-jitsu, the insurance companies are going to take these cases seriously. So if someone gets injured, right, and they break their leg or break their neck or, have some sort of brain injury, right, the insurance carriers now, the adjusters are going to remember this case. And they're going to pay that $1 million policy, make sure the person's taken care of right away. And, this case was from 2018. It's 2023 now. This kid had to fight for 5 years to get paid, 5 years to get help, 5 years to get justice. And I think this is going to help, all practitioners because it's going to make it so insurance carriers take these injury cases more seriously, do their job at both protecting the school, but also, getting money to people who are seriously injured. The only negative I could see here is that premiums might go up. You might see an across-the-board premium increase on jiu-jitsu schools, rock climbing, gyms, et cetera, because now these carriers are going to be like, we need to totally change our risk profile. We need to add more to our premiums to cover all the money we're going to have to pay out now in the future.
I agree with that. And I think that is an issue. I wonder how much premiums are going to raise up. But also, I don't believe in means to simply an ends. I believe you shouldn't use, make sure that everything turns out all right and ignore what people are really saying and people's culpability. And I say all that to say, I'm not going to let Rener off the hook. Okay. Because I watched that video and his breakdown was good. And I think we can now all agree and everybody agrees that this was simple negligence and not gross negligence, but we're all okay with the result. And we all understand that the insurance company should have known that, that somebody could convince a jury this was gross negligence.
Yeah. And also, I don't know why all the hate for, for Gracie, because at the end of the day, he didn't give an opinion about what the legal ramifications are of what happened. All he did was break down for a jury what the instructor did wrong and what the instructor should have done. But it's the lawyers who are making this argument. The lawyers are the ones who are, opposing the summary judgment motions. They're the ones who are arguing gross negligence. All Rener did was say, look, I'm an experienced practitioner. This is the way it should have been done, and this is the way it was done. And because of that, there was some level of negligence here. But it's not him who's arguing whether it's gross negligence, whether a waiver should be thrown out. So I don't think he deserves all of the hate he's getting. I think he did his job to break it down. I think he did a very good job, right? But it's really the lawyers who went in there and made the arguments that people don't like, not,
okay.
Mr. Gracie.
I disagree. Here's where we disagree. Here's my take. I agree with everything you just said about the breakdown and the video and everything. I have no problem if he had just explained that. So then he talks about, well, I maybe said there was spiking involved. And what I meant by spiking was a head balance. And again, so now when we get into this, what I said and what I meant, now I have to wonder, are you being honest? And here's where I have a problem with, and you and me can, I think, discuss,
Sure.
Me and you can discuss what you think about this, but let's talk about a few things that he said that I don't think are honest. I think it's dishonest. And I wonder if you would agree, and I disagree with him. Number one, he was pretending that there was some industry standard about black belts rolling with white belts and separating the classes so that white belts and black belts didn't roll together. Have you ever faced that in any of the places you go?
I mean, look, I think that's absolutely untrue based on my personal experience, right? As a jiu-jitsu practitioner, and I trained a lot. I trained with you in Texas at University of Texas. I trained, at several schools in Texas. I trained at 3 or 4 schools in, LA, a Machado school, a Gracie school. I trained with Eddie Bravo. So, I have like a pretty broad experience training in jiu-jitsu. From what I understand, he has like a Gracie U online school, right? Is that accurate?
Yeah, he has an online school where you can earn up to a blue belt through.
Right. And I think part of that is just a sales thing for his own school and method. But I think it's absolutely untrue that black belts and white belts get separated. I've never been to a school where even on your first day, if you want to in live rolling roll with a black belt, you can't. I mean, usually in those situations, the black belts will go really easy on you. I've rolled with brand new students and I'm a purple belt all the time, and there's no rule that prevented me. Sometimes they'll separate classes where there's like basic and advanced, where it's like white belts and blue belts. And then, you may have a class that's purple belt and higher, but then there'll also be open mat days where everyone can roll together and there's no restriction. So I just think that's a fantasy. I think it's a fiction.
I agree, and so that's number one. And if he said that, and he seems to say that, and I from at least in his deposition, he did. I don't know what he testified to. I've only seen part of it, but what I've seen is from his deposition, a transcript from his deposition. He said that. So that's number one. I don't think it's true. Number two, and relatedly, this is the craziest part. He said, in general, black belts, the industry standard. And again, that is talk where you're talking about legal stuff. You see what I'm saying? That really does apply to lawsuits and really does sink into the jury's mind when you talk about industry standards. But what he said was that it's an industry standard, or that it's regular occurrence, or he does it in his gym maybe. But he said it was an industry standard, but that the black belts don't generally practice moves on white belts, that the instructors don't practice moves on lower belts, that they haven't taught that lower belt. And that to me is absolutely crazy, bananas, impossible. It's not only not true, it's impossible. I couldn't even think of how to only roll with the white belt on techniques that I've taught them. That's just.
Well, if you think about it, that's impossible, because what do you do the first day you roll with a white belt when they know nothing? You just lay there like a dead fish and don't do anything.
Yeah, it's crazy. So that right. You agree, untrue if that's was ever said.
Yeah.
And then he said that this was a high risk move, is what he was saying. And basically, he was kind of using the ins to say what he did, but basically he was saying it's a high risk move. I would not call this as the Leo Vieira roll, is pretty much what it's called, a front roll back take. Basically, I would not call this move in any form a high risk move if you told me about it before. It's not like spiking someone on their head. It's not like a takedown. It's you're both on the ground. You both stay connected to the ground. You know what I'm saying? And I've never seen this before. And the number one thing is, to me, to be a high risk move, you have to man, people get injured over this move a lot. This is something I see, the heel hook is the classic example. Well, the reason the heel hook is a high risk move is because on a lot of heel hooks, a lot of ankles and knees are torn apart.
Out, yeah.
And so when you say it's a high risk move, I've never seen someone really hurt on a front roll back take of any kind. Would you agree with me?
I mean, look, when you first told me about this, before I went and looked into it, I was thinking maybe he stacked them, right? Because you see in gyms all the time, people are in guard, they get frustrated, and they start stacking someone. And it's really obvious when you stack someone, you could hurt their neck, right? You could paralyze someone. I've seen in jiu-jitsu tournament videos, people actually break their neck getting stacked. So, when I heard they got spiked on their head initially, the words that he used and you use right now, that was what I initially thought before I saw the video. And then I saw the video, and, I agree with you on all those things, but I still think it comes down to, at the end of the day, he said, look, this is the proper way to do the move, which is, you do it under the arms. You don't tie up the arms, right? The black belt, he had the experience to know that, and he did it improperly. It put the student in unnecessary risk, and the jury, who is not experienced in jiu-jitsu, agreed. But I don't think he's a bad guy for doing that. I don't think anything he said about the technique itself was inaccurate, right?
I would agree about the technique, but
right.
Here's the thing when I rolled, and it kind of tied in what we said before,
Sure.
Which I think, again, I can only speak for myself, but to be clear for anybody, I roll with many, many belt levels from white to black 3 times a week, every week, unless I'm injured, which was maybe 6 months maximum and almost never. But for now over 15 years straight, almost no breaks. I roll with these people. I'm in this community. I've trained at least over 30 gyms. You know what I'm saying? With hundreds of black belts. I agree when you broke it down, what caused this injury? Exactly what Hinner said. But for me as a black belt to be doing that move where I don't have the over under, but I do have his arm trapped and I went to it, I don't think even Hinner Gracie himself would, in that thing where he had it, be maybe in general, if he's just like, well, I'll just do a different move, which there's lots of different moves, but it's just like chess, excuse me. It's a lot of different moves at any point, there's a lot of different moves. And so the fact when I look at that and I see he chose that, to me, I would never put it in my brain that, oh, that black belt should have known or even could have known that move would result in any increase in risk over any of the other moves.
Yeah, but you remember, intent has nothing to do with negligence or gross negligence, right? This isn't an intentional tort. You don't have to have any knowledge that what you're doing is an extreme departure from the ordinary standard of care. You don't have to have any knowledge that what you're doing is negligent, right? You know, when I drive the car and I rear end someone because I'm not paying attention, in the moment, I had no idea I was doing anything wrong. I was staring off into space and, you know, I hit the car and then I'm like, oh shit, I messed up. But I do agree with you here that.
But hold on, but that's true. That's not intent. But what I'm saying is, in order for me, let's say I had used cruise control, advanced cruise control on a car, right? That stops the car for me. And I had relied on that, done that hundreds and hundreds of times, right? And then it doesn't work and my car runs into the back of them. And then I go, well, I didn't know. And they go, well, in this particular incident, this cruise control doesn't work. Okay, but that's not me violating.
That's not what happened here. That's not what happened here.
Well, what I'll say is,
it would be more like you have cruise control and then you hit it every time correctly. And then one time you don't hit it correctly and then you rear end the car in front of you. Because here, it's not like he did the move correctly. He did the move incorrectly, right? You know, what you're saying is like he did the move correctly 100 times, then the 101st time he does it correctly, someone gets injured. That's not what is happening here. What's happening here is it's the hitting cruise control every time, and then the last time when it doesn't work, it's because it was an operator error, right?
Well, that's what I don't know. I don't know that again, I don't know that's how any of this.
I don't think anyone's disagreeing that the mechanics of how he was injured was because of where the arm position was. And I don't think there probably was any defense testimony that said that. I think what probably they were saying is this just isn't negligence. This isn't, a deviation from the ordinary standard of care. And then they probably challenged the injuries as well.
I don't think it is, because here's what I'll say. Again, pressing a button, cruise control, you know it works or doesn't work. Do you see what I'm saying? But if you could prove that, what I'm saying is he did the move incorrectly, I don't know that there, again, like you said, I think
we both agree that it was simple negligence. I think we both agree it was an accident, right? It was not rising to the level of an extreme departure. I think, for example, if he stacked him and broke his neck, that would be gross negligence. Because a black belt in jiu-jitsu should know you can't stack people because you could injure their neck. Or if he did a heel hook and just ripped open his knee and blew out his knee and the guy could never walk again, that's an extreme departure from an ordinary standard of care, because a black belt should know full well that a heel hook's dangerous. A black belt should know you can't, hit it too hard, right? And, that would be gross negligence. So we agree, me and you agree, that this, in our opinion, is ordinary negligence. However, like I said before, when you're adjusting these cases, right, and when you're determining whether or not this verdict was a just and fair verdict, you have to understand people just don't have the knowledge we have. People just haven't experienced that. They are not in a position to opine on whether or not what Henner said is accurate or inaccurate, whether this was dangerous or not dangerous. And you have to understand the risk profile as an adjuster and pay the money, because there is a risk that the jury is going to find gross negligence because the injury is so severe. So I don't think we're disagreeing on anything.
No, I well said, and I agree with that. And let me get to one last thing I think I want to call Hinner to task on, and kind of not even call him to task on.
Get him on your podcast, man. Let's do it.
I don't know the man. He's a way better practitioner than me. Let's just put that out there. I don't think I'm even near in the league as Hinner. But what I would say is I do know certain things. And the problem I had is at the end of his video, he kind of is like, look, it's no big deal. The waivers work, except we don't know if the waivers work. Because in this particular circumstance where we're saying it's simple negligence and this guy got a waiver, the waiver didn't work, right? And so there's no answer there. The second thing he said was, this is such an individual thing where, and again, I don't mind him saying where is a catastrophic accident. That's the one thing here that I think me and you can agree is unique about this case, is the quadriplegic nature of this thing.
Like I said, if this was a broken toe, this would never have happened, right? The court would have thrown it out, right? Or a jury might not have found negligence, even if the court let it go to a jury trial. Because really, people get emotional about it. You know, I know you have a lot of trial experience, and I've done, a lot of trials as well. And I can tell you the results in my trials have just as much to do with how my client presents and how hurt they are than the facts of how the accident occurred. I've had some really sketchy liability cases get really great verdicts, and I've had some really great liability cases get really sketchy verdicts, right? And a lot more had to do with the plaintiff and how they presented and how hurt they were than the underlying facts, right? And I think that's just the same here.
100%. And what I'll say is, I'm only calling Hinner to task on his breakdown because I think it's dangerous for the public to misunderstand exactly what you're saying. This is individual. This is a unique thing because of the severity of the damages. But what Hinner says, which is like, this is a unique case because, black belt instructors don't usually roll with white belts. And he went down this whole line of things that do actually happen and are not unique at all. There's no uniqueness.
This stuff happens every single day. I guarantee you today, at 100 jiu-jitsu schools across the country, a black belt is going to injure someone by accident. It's just going to happen every single day, right? I would be shocked if it didn't happen. It's just the level of the injury here that's unique.
But so what I want to do is not give Hinner credit for that wrong thing, but I actually do want to give credit to the whole justice system and everybody. Again, now what I'll say is,
that adjuster probably got fired, is my guess.
Well, here's my thing. Hinner did, if it wasn't Hinner, it would be somebody else. There is no case where you can't find an expert who's willing to maybe exaggerate a little or kind of go a little on what the industry standard is or something, who will say that stuff for $100,000 in a court. If it wasn't Hinner, it would be somebody. Would you agree with me?
You don't even need someone who's going to compromise their morals. It's that this is such a subjective situation that there are people who will strongly feel like there was gross negligence, even if they have experience in jiu-jitsu. Right? So I don't even think you need to find someone who has questionable morals. Maybe Hinner is really being sincere in what he's saying about it. Maybe he runs his jiu-jitsu university online based on the principles that he feels are the safest for students. So I don't necessarily think you can say objectively that he's exaggerating his opinion. It could just be he runs his school in that way because he feels it's the safest way to run it. I'm not defending him. I'm just saying there's an alternative explanation as to why he testified and the substance of his testimony.
I think you could be right. What I would say is I don't think you're right, because what I see is he was saying what was normal practice and not just at his place, what was normal practice and what was an industry standard. And again, when you get those things, that's not subjective to me. That's an objective thing. I can walk into any school tonight and check if that's a standard. Any school, pick a school.
So, but I kind of look at the parallel of let's say epidural injections in personal injury cases, right? You can find 50 doctors who will charge $15,000 for an epidural injection. They all know each other. They all do personal injury on liens, right? Or I think they call them letters of protection in Texas, right? But then you could find another, 100 doctors that do epidural injections for $500 on Medicare or through PPOs, and they'll say that the standard is 500 an injection. Then you go to all these doctors who do $15,000 injections, and they'll all say the standard is 15. And then you go to a jury and they have to kind of figure out who's full of it and who's not. And the truth is that there's like two parallel systems of billing. You have the doctors who bill 15,000, the doctors who bill 500. And it could be in jiu-jitsu that all the people Rener hangs out with have their system of what they think is the standard of practice. And then you have the majority of schools that just don't feel like that. And I'm not, like I said, I'm not.
I don't think so. I can tell you, I don't care. I don't believe that. You may be right. And maybe he lives in a magical world where that happens. But I think you could probably go to the school a block from him and go to all his cousins' school. Sure. By the way, the person who testified on the other side was his cousin, second cousin. Sure. That's what's so funny. And so what I'm saying is I get what you're saying and I agree with that. But if someone testified that the epidurals were $15,000, right? And I went to 100 doctors randomly, not just in the poor part. I'm talking about I went to the high quality, the mid quality, and nobody was charging that. Then at some point you got to stop and say, stop. This is not an industry standard. That is not what they actually cost. You can go into court and say, that's what I think they're worth. That's what I charge, whatever. But the minute you start even hinting that this is an industry standard, then you got to show me 2 or 3 examples. And I'd like to hear that. If you want to give me,
live in a big country, my friend, there's 2 or 3 examples of everything you can think of.
But Rener doesn't know them. Rener does not know them. Rener does not know them. And the industry standard is a different thing than finding 2 or 3 examples. That's an industry standard. And he's saying the opposite, that everybody I know, including some really big names in jiu-jitsu who are as expertise as him, are saying, no, I've never done that. What is he talking about?
I mean, it really comes down to, though, like I said, all of these things are risks that the insurance carrier should have taken into account and consideration and adjusted this claim correctly. I mean, like I said, I don't have any skin in the game for whether he's right or wrong or whether he exaggerated. But what I will tell you is that I don't think there's anything wrong with 80% of what he was saying. I think the majority about the breakdown of how it happened is fine. Maybe he exaggerated, maybe he didn't exaggerate. I'm just giving alternative explanations. I'm not saying which one I endorse. But at the end of the day, right, I think that this is going to be a huge moment for jiu-jitsu schools, jiu-jitsu operators, where they're going to have to start taking into account, what can we do to prevent these things from happening? What can we do to make schools safer, right? And it might be changes that have nothing to do with this type of conduct. It's like when there's a shooting, right? And people start trying to pass gun laws, and the gun laws don't relate exactly to how the shooting occurred. The gun laws they pass wouldn't have prevented the shooting that occurred, but it gets people to re-examine how they, look at guns or the laws surrounding guns and ownership, right? And people are going to go who own jiu-jitsu schools and look and say, hey, look, what else is dangerous that we could mitigate the risk a little bit? What else can we do to make it safer for students? So I don't think this is necessarily a bad thing. I think that we'll see over the next few years a lot of changes to jiu-jitsu schools because of this.
And I agree. And that's what I want to end on, in fact, because I think we've pretty much covered everything. And I want to end on what you—
And I got to go back to ambulance chasing. So.
Yeah, you got to go back to ambulance chasing. I got to go back to getting, child molesters free. No, by the way, I'm deleting that whole gun thing. There's no way I'm putting— no, YouTube will ban me so fast. No. What I'd like to end on that's important here to me is— I can say Rener was wrong about his breakdown, but in the end, it doesn't matter, because what you said is the most important part, which is the one thing we can take away is jiu-jitsu instructors don't have anything to fear as long as they have the insurance.
Sure.
Almost any state, unless they're completely really wealthy, in which case get even better insurance. But in almost every state, in almost every court, the only time you're going to get this bad result is if the insurance company doesn't do what they're supposed to do. And even in that case, the instructors, the gym owners, everybody is not the one on the hook. I think that's the most important thing to kind of end on here, which is no matter what Rener did, no matter what anybody did, no matter what the jury decided, it's just like we can pontificate and talk about, you know, ambulance chasing and all that stuff. But in the end, if the only people who are out of pocket are the people that we are all paying to make sure that money doesn't come out of our pocket, then there's no loss. There really is no loss. It was up to that insurance company to mitigate. And by the way, it goes back to my number one PI advice. You can go watch that video, which is the insurance company is generally not your friend. It's
absolutely not. Yeah.
It's a conflict of interest that they want to pay less for your claim, and they don't even have to listen to you in regards to just pay the guy. Because I think every single gym owner in the country, except for a few really bad D-bags, if they found out that this kid got injured, accident, whatever, it doesn't matter, completely his fault. He's paralyzed, injured, whatever, you just want the insurance company to pay him. And that's it. That's why you pay the insurance company every month. They don't pay anything every month that you're paying them. So I think that's important, which is like, this is not a crazy, gym owners, nobody's going to be able to own jiu-jitsu studios, nobody like that. No, one thing Hinner almost got correct is have good insurance. I don't even think the waivers really matter that much, but go ahead and do the waivers. Don't come see me, an attorney, about the waivers.
The waivers will help for like the minor injuries where
Correct.
attorneys won't take it. It's more like an obstacle that if the damages aren't high enough, no one's going to want to take the case as a plaintiff's lawyer, right?
Yeah,
so it does help you. The waivers do help you, but it's not going to help you in a catastrophic injury.
Yeah, do the waivers, but it's also, again, I think there's a whole implied waiver thing in most states anyways, but do the waivers anyways, but don't go to an attorney to get your waivers done, because the whole thing is just make sure you have good insurance and that your waiver is up to snuff. Go ahead and do that. But the more importantly, just exercise good safety habits. Make sure your gym is as safe as practically possible without compromising the art, and then have good insurance, and you're covered. Just do the right thing, be a good person, and have the good insurance. And just like anything else in life, it's covered. And don't let this make you think that this is unfair or anything. This is probably a just result. A kid was injured, catastrophically injured. He was doing the art that he loved at a place. He was going to be out hundreds of thousands of dollars and hundreds of thousands of dollars in future earnings, right? If not millions of dollars. And now instead, he's got a nice nest egg from the corporation who's supposed to do this sort of thing.
It's going to be way out way more than that. I mean, let's say he would have made $100,000 a year over the next 50. That was 23 years old, right? He's going to work 50 years, or he would have worked 50 years, right? And then he's going to need 24-hour care because he's a partial quadriplegic. So I don't think the damages at all were unreasonable in this case.
No. And so that's my whole point in the end, which is like, maybe we can get into all the nuances and where things went right and went wrong. This guy was injured. He's going to be compensated for his injury and not have to be a burden on society, by the way, or anything else. He's going to make out, and the only people who out is the insurance company that are paid to do it. Would you agree with me? That's a good summary of what's going on.
I would. And just one more thing, and this is, I don't want to go down a rabbit hole, but just one thing to bring up, because this is something that I think 99% of people don't know. It's also very possible that there was a high-low agreement prior to the jury rendering their verdict. Are you familiar with high-low agreements?
Yes. Essentially, it's like a cutting your losses on gambling. It's like, here's the minimum, here's the maximum, and correct. If the jury finds under that, we'll still pay you. It's kind of like an insurance policy on an insurance claim.
Exactly. So, this firm, Panashamboyle, right, and Ravabudi, basically, when they came in, the insurance company probably brought in a different defense firm that can handle a big plaintiff's firm like this. And it's possible right before trial or even during deliberations, they had an agreement they made, and that agreement was that, look, we understand there's a lot of risk for us on this open policy, and we understand there's a lot of risk a jury might not find negligence. So they might have made a high-low that was, let's say, $1 million, which is the policy, and $20 million is the ceiling. I'm not saying that happened, but it's extremely common in these cases. And also, it guarantees that the plaintiff gets paid immediately. Because in the high-low agreement, everyone waives the right to appeal, everyone waives the right to challenge it, and then the second the verdict is rendered, you can get a check to the plaintiff immediately. So just to put it out there, it might not even be the $45 million. it might be that there was some high-low and the plaintiff is going to get paid pretty quickly.
And also, if there wasn't a high-low agreement, there's also a chance that because there is appeals and because of all that, that they can, there's almost always post-judgment negotiations where they say, hey, we won't appeal it. We won't drag out the time. We'll pay you 20 million now. Or again, it could be 42 million instead of 46. It's up to them. But my point, I think your point is that this isn't, don't let the headlines fool you onto what this means, and don't let r/BJJ fool you on what it means to jiu-jitsu.
Sure,
this is probably a good thing. Again, the thing, everyone's painting scumbag lawyers and scumbag expert witnesses and all that, but really what ended up happening is everybody won here, most likely. And
the lawyers were heroes here. The only scumbags were the insurance carrier who took all the risk of this trial and threw it on the gym owner, right?
I agree.
If it wasn't for lawyers like me and you and other plaintiffs' lawyers, then insurance carriers would get away with this all the time. And now there'd be a gym owner with a $45 million, $46 million verdict against them. And it was because the insurance carrier gambled with, someone else's money.
Correct. All right. And that is because of lawyers. That's what I say. Get a good lawyer, get a good attorney like yourself. And you'll get a good result. Again, it's hard to find. There are a lot of scumbag lawyers out there, just like there's a lot of scumbag gym owners and a lot of scumbag students, and scumbag experts. There's also good experts, good attorneys, good instructors, and even some insurance companies are better than the others, and insurance adjusters. So get a good lawyer, I think, is the final thing. But I just wanted to break down. I really appreciate you helping me to break this down for people to understand that maybe this wasn't as unreasonable, as crazy as it seems. Yeah.
Well, I appreciate it. Thanks for having me on. And, hopefully make it out to LA sometime soon.
Dude, you got to pay. Just pay. I'll come on. No, it's good. All right, man. Well, you have a good one. It was nice talking with you again. And I'll talk at you later, brother. Have a good one.
You too, man. All right.